Well, since President-elect Donald Trump's decisive victory last month, there has been a lot of discussion about what a second Trump administration will mean for the Department of Justice, what it will mean for states across the nation, as we'll see maybe the federal government kind of pull back and let states conduct business for themselves. Now, one of the things we saw during the Biden administration is that we saw state attorneys general across the country, Republicans. There's about half the states. They spent a significant time and lots of resources challenging the Biden administration and their leftist policies. And they were quite successful in keeping them contained. Now, how will that change come January with an ally in the White House? Joining me now in studio to discuss this is the Attorney General of the state of Louisiana, Liz Murrill. Liz, welcome to Washington Watch.
Thank you. It is great to be here in the studio with you, Tony.
Well, it's good to have you here in Washington, D.C. In fact, we were on the commute up here this week. We're on the same plane, and you enjoyed all of the normal commuting problems we have coming up here, where we got stuck in Charlotte. So let's talk. I want to get into some of the cases in Louisiana that are very interesting, and even President Trump has weighed in on those. But first, you and your Republican colleagues played a key role in containing the Biden administration and their reach. I mean, it was a constant, nonstop. How does that change now?
Well, certainly we're not going to have to sue the federal government quite as much. I don't think it means that we don't have to sue them at all, because a lot of these rules have gone into effect, and we still want to block some of the rules that did go into effect that lawsuits may not be pending on yet. So it doesn't mean that part goes away, but it does mean that we have an ally in the White House who sees the kind of regulatory power and regulatory overreach the way that we do. And so that we can kind of take advantage of that, go in and talk to them about some of the pending lawsuits that we still have that are open, and see about how we can settle those and close those out, and what that looks like. You know, it may be settling cases. It may be repealing rules that are in place. It might be, slowing down compliance deadlines and then engaging in a withdraw, repeal, and replace process through rulemaking. We don't anticipate that the need to litigate and defend those actions is going to be any less great than the need for us to sue on the rules that we challenged in the first place.
So you will actually play a role in helping the Trump White House deal with some of the cleanup that's necessary for the agencies that are still operating under the rules left behind.
We will, 100% we will. And, I think I've spent some time already working with my team to go back and look at all of the open cases that we have. We had a lot of lawsuits on energy policy. We have one of the large coalitions that sued on the Title IX rules. Right. So there are a lot of things that we want to sit down and talk to them about and see, what can we do, how fast, how quickly can we do it. Some of those actions are going to be more complicated and take a longer time than others, but we want to do everything we can to help them be as successful as possible.
Now, the positive steps that the Trump administration takes to advance good policy is now going to be challenged probably by some of the Democratic attorneys general across the country. But you'll have the Republicans will play a role in that as well, will they not?
Well, we will, and we've kind of been through this drill once before. The Democrat attorney generals will do the same thing that we did when President Trump was president before, and they will generally file the lawsuits, and then we will come in as interveners in a lot of those cases and help defend the rules and explain why new action is necessary and appropriate.
So it's not going to slow down.
No, it's not going to slow down at all.
But we may see more victories in playing a little more offense than defense.
Look, there is no doubt that we are much better off now with having a friend in the White House. That there's someone that we can talk to. I believe that the policies of this administration are going to by nature, they're going to revert to being more friendly and respectful of state sovereignty. The Biden administration absolutely was not. I mean, they wanted to remove power from the states, concentrate power. Even in the oil and gas sort of zone, they would like to concentrate more power in bigger oil companies and take it away from small businesses. All of that is destructive to democracy. So I think that we've got an administration that believes that democracy will survive in part by preserving the structure of our Constitution that respects 50 states that all have the ability to make different policy for their own people.
All right. I didn't tell you I was going to ask this question, but you're good. You can think on your feet. Before becoming Attorney General, you're Solicitor General, and you argued many cases in Louisiana, and you took one of the cases all the way to the Supreme Court.
5.
Well, the one that I want to...
Actually, about 9.
One I want to focus on because I did the initial legislation that was built upon over the years, and that was the Abortion Clinic Regulation Act. You took that all the way to the Supreme Court prior to Dobbs. We didn't prevail in that case, but we were. I think that played a role in setting the stage for Dobbs.
Oh yeah, I agree with you. I mean, I explain it often as we loaded the bases and Mississippi was able to kind of make the home run.
Right.
But it takes time in Supreme Court. In the world of Supreme Court litigation, you kind of have some layups before you actually get the ball in. And so I think that is by nature. It's by design that they move slowly and incrementally. And when they're reversing precedent like that, it's
stepping stones.
It is.
To get to there. My point, and you have, Louisiana's a pro-life state.
Right.
Our laws are pro-life. You're pro-life. We've worked together on a number of things. There's an issue with the current FDA and mifepristone, the abortion pill, because Louisiana's a pro-life state. We have laws that say that we're going to protect the unborn, but that's being violated by the FDA.
Yeah, there's a lot of problems with the way this administration has handled it. It started in COVID. It started when, they took advantage, and I would say, the pro-abortion organizations like Planned Parenthood took advantage of the opportunity to go in and remove some of the protections that existed, like the REMS protocol that had previously been in place for mifepristone. And, that had a lot of advantages where they recognized that there is an inherent danger in inducing an abortion by the use of these medications, that more than half of them require additional procedures to complete it, and that women can become septic, they can hemorrhage and die. And so this movement that has been so aggressive to pretend like those risks don't exist, and then to push those pills out into our states and make them accessible by mail without any relationship with a doctor, it's very dangerous.
And now almost 70% of abortions are being done through the abortion pill. So the FDA is the one that issued that order. What if that order is not reversed and we see that same policy under the Trump administration? Well,
it's still illegal in Louisiana to prescribe those pills. I mean, you can prescribe them for other purposes, but not for the purposes of inducing an abortion. So the FDA can't change that. Our state laws still prevail when it comes to whether or not you can use those and have chemical abortions.
But if they're coming across state lines by mail?
Well, it's a different problem that we have to deal with.
That is a federal problem.
It is it's a crime. I mean, it's a crime in the state of Louisiana.
It's a crime, but it's being allowed because of federal policy.
Well, and I would expect that a new set of U.S. attorneys and a new set of people in charge, both at the FDA and HHS, but more importantly in the Department of Justice, is going to help us, allow us, and help us in enforcing our laws.
Well, that goes back to the Comstock law at the federal level, where these cannot be mailed.
It's illegal under federal law, too.
Right. But they're doing it anyway, and the Biden administration has basically said you get a pass.
Right.
Okay. I want to go to a particular law in Louisiana that your office has been spearheading to defend. The Ten Commandments in public school classrooms. It's been at the district court. It's now at the Fifth Circuit. You had arguments, I guess, last month at the district level.
District court level, that's right, on a
And-
preliminary injunction. So still
Give us
an
an
earlier
update.
stage. I mean, for non-lawyers, preliminary injunctions are still an early stage of the litigation. Not supposed to be a final judgment on the case. But this judgment looks a lot like a final judgment. I think the judge intended it to be viewed that way. He also intended, I think, to chill any school board from complying with the law, even though only 5 school boards are actually defendants, and therefore only 5 school boards are subject to the jurisdiction of the court and to his order. But, we are on appeal at the Fifth Circuit. We were able to get the case expedited for oral argument, which means that we are going to be arguing it in the Fifth Circuit on January 20th. We've asked the Fifth Circuit to go en banc, so that means we would have the whole complement of active judges on the court ruling on the case instead of just the panel of 3, because there's some Fifth Circuit precedent that we think only the en banc court can sort out. Mm-hmm. So if they do that, we'll get a pretty good hearing, I think, from the Fifth Circuit, and the case will be teed up pretty well for the United States Supreme Court.
So you believe it'll go all the way to the Supreme Court?
I do. One way or the other, it will. I mean, if we win in the Fifth Circuit, then our law goes. I mean, then those, no other school boards are enjoined. All the 5 that were sued can implement the law as well, and that's not really going to be an outcome that I think the people who sued us can accept. So they will go to the Supreme Court if that happens.
And so just so our folks, our viewers and listeners know, what this requires is a posting of the 10 Commandments. It lays out the size. It's got to be read, readable. There's no government money that's expended in it. These are given. So, people are publishing these 10 Commandments to post them in the classroom. And the argument against them is what?
Well, I mean, I don't agree with the argument against it, but the argument against them is that it violates the Establishment Clause. That how they get there is where a lot of our fight is, because we think that you can comply with this law and apply this law in a way that is constitutional. And that kind of brings us to 2 cases that the Supreme Court has decided involving posting of the 10 Commandments. And in one, they said it was a violation of the Establishment Clause, and in the other one, they said it wasn't. And the one in which they said it wasn't was a case where it was presented in an historical context, and which means that we illustrate the 10 Commandments and how they played a role as in the founding of our country.
It's pretty hard to deny that they played a role.
Well, certainly our legislature overwhelmingly agrees with that, as I do, and I think that this is an opportunity for us to be able to put it in in a poster, a small poster that creates a point for talking, for discussion, for teaching. And, so I had a whole press conference and with about 15 posters that my staff thought of and we created, and we posted them so that we could illustrate to the press and in our briefs. We used them in our briefs to show that there are a lot of ways that you can apply this law and it still be constitutional, which means we should win. In a case that's challenging it, saying that there's no possible way to apply it constitutionally.
I mean, it should be pointed out that the 10 Commandments were in public schools until 1980. Mm-hmm. And that's when there was a court decision that struck down the posting of the 10 Commandments. So this is not like new. It's just returning to that which maybe, given all of the problems we have in our country, maybe exposing the kids to thou shalt not kill, thou shalt not steal, might not be a bad idea.
Well, and those commandments, for us as Christians, they're meaningful to us in a lot of ways, but they also are built into the law of virtually every country, not just ours, but every state, every country.
The very Supreme Court in which you are arguing the case.
The federal law. Well, the Supreme Court has in 9 different places, Moses and the tablets are there, and so there's a lot of teaching, I think, points that are opportunities that arise with this. But to the question of whether we can just post the 10 Commandments, I mean, we're going to test that precedent.
Well, we are glad that you're there, Liz. You're doing a great job, and we look forward to tracking this.
Thank you for having me.
Thanks for being with us, and Merry Christmas.
You too.